Welcome back to the PI show. My name's Harry Nowicki. I'm a common law lawyer, and this is my colleague Tony Carbone, both common law lawyers, talking about injuries and the common law in Victoria. We're dedicated to helping people and preserving common law rights in Victoria. That is decisions made by judges and juries in Victoria to help people who are injured. Tony, the final issue we're going to talk to viewers today is what's called limitations of actions. So the law says in Victoria that you have generally 3 years in which to commence proceedings for common law for what's called public liability matters. So if you don't commence proceedings within 3 years, the other side, the insurance company, will say you're out of time, bad luck, you can't proceed. Two extreme examples where this issue arose, I think, very dramatically, is in what's called the Voyager cases. There was a collision between HMAS Voyager and HMAS Melbourne on the 10th of February 1964, a long time ago. And people who were on board the ship, there were 80 lives lost. A number of sailors who were on both ships in the 90s went to court and said, I'm suffering mostly psychiatric injuries as a result of the Voyager case, Voyager collision in 64, 30 years after the event. How is this possible?
Well, the law looks at a number of things. It looks at prejudice upon a defendant and looks at the person's state of knowledge. Now, in the Voyager cases, what the courts have looked at is when the plaintiff have knowledge that he had an injury,
well,
which gives rise to a court of that.
The plaintiff had knowledge straight away. He was on board the ship. The Voyager, was, I think, cut in half by the HMAS Melbourne, and it was chaos. The person knew straight away on the day it was traumatic.
Well, the people knew they had symptoms, Harry, but as to whether they had
30 years later?
Yeah, as to whether they knew they had a legal right to sue, a lot of people didn't. They didn't know that they had a post-traumatic stress disorder, but they had a psychiatric illness that qualified as an injury.
How does a lawyer argue before a judge that 30 years later, someone who's on that ship is suffering from an injury and the court should look after them?
Well, the relevant legislation talks about state of knowledge of the injured person. So what they argue is that it's a disease, it manifests itself over time, and they look at the date that the person becomes aware that he has a cause of action, which is when they consult a lawyer.
Someone who was 18 years old in 1964, 30 years later, can go to court and say, I've got an injury.
Yeah, they ring up the solicitor. The solicitor says, yes, you've got post-traumatic stress. That's when he becomes aware he's got this an injury which qualifies or gives him rights to sue under the legislation.
So he's got to see a lawyer or see a doctor and complain about what flashbacks, nightmares, all these things that arose 30 years ago. Isn't it stretching a long bow?
It isn't, it isn't. The courts look at prejudice upon defendants. You're talking about public liability cases now, but in a lot of instances where we see people out of time, it's Accident Compensation Act in Victoria and also Transport Accident Act. You've got people that have had injuries 6 years earlier or outside 6 years. They put in claims outside the period and the courts say there's no prejudice on the defendant because in a lot of circumstances, what happens is the insurers get circumstance reports, they haven't been examined by doctors, so there is no prejudice.
But, I mean, there's no doubt they had a Royal Commission into the Voyager and HMAS Melbourne collision. There's cover-ups, there's all sorts of things that went on. So no doubt about the accident and what happened and who was at fault. I think the captain of HMAS Melbourne was at fault, I think. So there's no issue about who was at fault. The only issue really was when did you, who were on board the ship, really suffer an injury? Which or what point in time? Because 30 years later, you've led a life, you've gone, probably left the Navy, gone on and done other work, maybe had other injuries. When does it all stop? Does the court just draw a line and say enough's enough?
Well, Harry, it's a tragic case, the Voyager, because, I mean, it's cost millions and millions of dollars. It's been bitterly fought by the Commonwealth. It's something that should have been brought on as a class action, perhaps, and it would have been disposed of once and for all.
Point, the class action really came into Victoria in the early 90s. You couldn't pursue class actions before that. The solicitors for the victims of this collision generally haven't done class actions. The Commonwealth fought the Voyager cases tooth and nail. It's been a terrible waste of resources, in my opinion, fighting these cases and not having a roundtable conference to try and settle. It arises out of one dramatic incident.
I've got some knowledge of some of the settlements. There's been some big ones, and for similar injuries,
ones.
Very small. And a couple of people have actually missed out. One was a fellow called Katanaga. It was a pretty sad case. I mean, he had 2 or 3 failed marriages, and I'm absolutely mystified as to why he missed out.
But the court said enough's enough. In that case, you couldn't bring your claim. It was too old.
That's right.
Too old. The other, well-known case in Victoria was Stingle versus Clark. And Stingle was born in 1955. She says that Clark raped her in March and April 1971, long time ago. And she says that she suffered post-traumatic stress disorder in the year 2000. She then issued proceedings in Victoria in August 2002, and ultimately she succeeded. Now, how is it possible for someone who suffers, I don't know, a rape, whatever happened in 1970, how is it possible someone can then issue court proceedings in 2002, 31 years later?
Well, for one, she's got to know that she doesn't have rights, or she didn't know what her rights were. That's number one. 2, there's got to be no prejudice on the defendant.
There is prejudice.
Well, the courts look at...
There is prejudice.
Yeah. The courts
That's a long time ago.
Yep. Well, in her case, the way she got over the line is that she's got to show that she only became aware she had an injury at the time that she issued proceedings.
Well, she said she suffered an injury in she knew about her injuries or went and had got treatment in the year 2000. So she had from the 2000, in effect, 3 years from that date to issue. But it refers back to things that happened, and the courts generally have looked after plaintiffs who want to extend time.
As a rule, they have, yeah.
And in this case, they did. They extended time, and the matter ultimately went to trial, a trial before a jury, I think, and the jury awarded her $20,000.
Which is very light.
So,
Harry, it just highlights that it's important that you get advice from an expert, which is a lawyer in this area, because most of these cases turn on their facts, and things like education,
knowledge,
language barriers, knowledge, all kick in. So people should consult a lawyer.
But extensions of time. The law says 3 years, but if you're not within 3 years, the law then says, well, we'll allow you a period of grace, if you like, and it can be up to 30 years later on these claims. It's a very significant length of delay, but generally I think the courts, it's fair to say, have looked after plaintiffs. Yep.
We've done plenty, as you well know.
Yep. That's all we've got time for today. Thank you for watching the PI show. Please go to our website, send in any questions, queries, comments. We're very interested in feedback, and we'll be back with another show next week. Thank you for watching.